Hello, welcome once again to Leto's Law. I'm Steve Leto. Ran a 10-mile race today in Flint, the Crim. They give you a race number like that when you run it. And of course, they give you the shirt when you run it. And they give you one of these when you finish it. So that'll go on my shelf behind me where I put all the other medals that you cannot see while I do my show. I've got to thank Josh, who sent me another great article. And Josh just keeps hitting them out of the park. The man could be in a home run derby at this point because everything he sends me, like I said, beautiful stuff. This is an article out of the National Law Review. Headline reads, Second Circuit confirms rolling trash cans are not vehicles. And common sense prevails again. And they're talking about a story out of the Southern District of New York in which a court rejected a claim that an exclusion did not apply because a recycling bin on wheels was a vehicle under the applicable all risks insurance policy. So they're fighting over whether or not a dumpster is a vehicle. And these are the kind of arguments that only come up, it seems, in fights with insurance companies. And so it seems an absurd argument to make, but a lot of money was involved, so that's what happens. And the Second Circuit has now affirmed the district court's common sense decision. And so here's how it goes. 1070 Park Avenue Corp. is an apartment building on Manhattan's Upper East Side. Well, it's the business that runs it. And they had a gas leak after a bin with wheels used to collect electronic waste hit a gas line when it's being moved. Okay, so let's just picture a dumpster. The leak was quickly fixed, but 1070 Park Avenue's gas system had to pass an integrity test before the gas could be turned back on. 1070 Park Avenue then had to spend more than $500,000 upgrading their system to pass the test. So they then sought coverage under an all risks policy issued to it by Fireman's Fund Insurance Company. Here's where it gets real complicated. The policy excluded costs associated with the enforcement of any law or ordinance that requires the testing of a gas system for integrity. But it had an exception to the exclusion that would create coverage if the costs were incurred as a result of a direct loss causing physical damage from aircraft or vehicles. So if this damage was caused by an aircraft or a vehicle, then there would be coverage under the policy. So the 1070 Park Avenue Corp. went to court and said, well, it was hit by a dumpster. A dumpster's got wheels on it, therefore it's a vehicle. And they apparently tried to make that argument with a straight face. And when they lost in court, they then took it up on appeal and said, hey, the insurance policy doesn't define what a vehicle is. A dumpster's got wheels on it. You know, I realize $500,000 will make you make sometimes a weird argument, but come on. The district court rejected that argument. They granted summary judgment in favor of Fireman's Fund. And in short, the district court concluded that common sense established that the bin was not a vehicle. The Second Circuit recently affirmed that in a short order, a very short summary order. The court relied on New York law establishing that insurance contracts must be interpreted according to common speech and consistent with the reasonable expectations of the average insured. And so here's the thing. An insurance policy is a contract. I've had people call me, they say, Steve, I got in an accident. I have a claim. I filed it. My insurance company won't pay it. I think they're ripping me off. I think it's wrong. And I always say, well, what's your policy say? And I've had a vast majority of people who make that phone call say, I don't know. And I say, well, pull your policy out and read it. And they go, I don't even know if I have it. I'm going, well, you got one at one point in time or another. Even if you answer an ad on television with a cartoon or a little animal or something selling you insurance. Hey, a talking moose wants my credit card. They will still send you a policy. It's in the junk mail that you don't process mentally. When you get a bunch of stuff in the mail. Most people buy insurance policies and just go, oh, I've got insurance now. And they never bother to read the policy. But if you actually read the policy, it'll actually say, here's what you're being covered for. Here's what we cover. Here's the exclusions. We cover this, but not this. And there's often a definitional section in there. Now, the funny thing is, this policy here apparently did not say, here's how we define aircraft, and here's how we define vehicles. Okay? And so if they don't include that definition, then it's up to the court to figure out what the parties probably would have meant if you'd asked them at the time the contract was signed. Obviously, if you ask 1070 Park Avenue, they're going to say, oh, we assumed it meant dumpsters also. But no, it doesn't. So an average insured, the court explained, would not reasonably expect that an exemption that refers to aircraft or vehicles covers a recycling bin. So again, I'm not sure if it's actually a dumpster or a recycling bin or something, but it's not something you ride around in. It's not something you can get in and go someplace unless you're garbage. It's literally something that you put garbage in and somebody comes by later and dumps the garbage into something else. The only reason there's wheels on it is to facilitate the moving of the garbage, but it's not a vehicle in any sense of the word. So the bin's primary purpose was to store electronics pending trash collection. The context of the policy precluded reading vehicles so broadly that the bin was included within the scope of the term. In essence, when you lump the word vehicles next to the word aircraft, you probably didn't intend to convey that everything with wheels is a vehicle. The exclusion therefore applied, and 1070 Park Avenue was on the hook for their $500,000 bill. And according to the National Law Review article, the moral of this story is don't try to use your dictionary to stretch a term beyond what a reasonable insured would believe the term means and what common sense dictates. And as many people say, common sense is a misnomer because it's not very common these days. There's a bunch of different ways that you can, construct that sentence. But unfortunately, you do see a lot of this stuff in courtrooms. And for some odd reason, people blame the attorneys and say, it's not always the attorneys, it's often the clients. And, if you pay an attorney to make an argument, sometimes they'll make an argument that might fall right outside the pale, But I remember being in court, and there are days in court, at least in Michigan, the circuit courts, the trial courts, where they have a miscellaneous motion call. That's what they call it. It's Wednesday morning in Oakland County, Monday morning in Macomb County. It's Friday mornings in Wayne County. And so if you go in and you need the judge to make a quick ruling on something mundane on your case, they might say set it for a motion on miscellaneous motion call day. And so the last time I was in Oakland County Circuit Court on a miscellaneous motion call, I got there nice and early, and so did my opponent, but so did a lot of other people. And you can never tell how the judges decide which cases get called when. Sometimes they call them in the order that you check in. Sometimes they call them based on whatever the judge feels like. And so I remember sitting there, and you get to see all these people go up and argue all these crazy things. And a lot of times it can be fun because you're trying to figure out what these people are talking about. And so, a lot of times they'll get up there and the judge will know enough about the case where they won't bother with the introduction. They won't say, Your Honor, as you'll recall, this case involves an injured who is, a minor who was injured in a car accident at a high school football game or anything like that. So they'll just jump right into it, and you start hearing these weird facts out of it. You're like, what on earth are they talking about? And then as soon as they sit down, somebody else gets up with a case that has nothing to do with the last case, and you're like, whoa! And it's like somebody is like flipping through slides of like 15 different vacations, and there's no order to it at all. And so it can be interesting, but occasionally you'll see somebody who's making a weird argument like this, and you're like, whoa. And I remember, this always, I know someone's going to say, Steve, what's the weirdest argument you ever heard someone making? And the one that pops into my head was Wayne County. This is about 20 years ago. And a pair of litigants was up there in front of the judge arguing a motion to dismiss. Each side was asking the judge to throw out the other side's part of the case. And the underlying fact of the case, as I gathered from their discussion, was a drunk driver was on the Lodge Freeway. And the Lodge Freeway is a freeway in Detroit that's actually sunk down below ground level for much of it. And so if you are down there, if you get out of your car, you can't just walk off the road. You've got to go walk to an exit. So it's a very, very restricted little highway. And the Lodge Freeway has entrance ramps and exit ramps. And that's pretty much the only way you can get on or off the Lodge Freeway. And somebody who's a drunk driver got onto the Lodge Freeway at night, somehow got so confused and spun around that they were driving the wrong way on the Lodge Freeway. So they're driving northbound on the southbound side. And other people who are entering the Lodge Freeway are, of course, going the correct direction down the entrance ramp, which is the only way you can go, presumably. Except here comes this drunk idiot going the wrong direction, and he's sailing along, and he goes up the entrance ramp and runs head on into an elderly couple and kills them both. At least that's my remembering the facts. And you hear about those kind of tragic accidents too often to where you might have heard a similar story, but it might not be the same one. And the argument they were having in court that morning was by an attorney with a straight face who represented the drunk driver, who actually said, Your Honor, I want a ruling from this court that if we go to trial, that we get to argue to the jury that it was the fault of the elderly couple who died because they should have seen my client coming and gotten out of the way. And there is a theory in law called last clear chance, where if you have a clear chance to avoid something and you don't take it, sometimes a jury can say, hey, why didn't you take steps to protect yourself? Why didn't you stop that from happening? And everyone in the courtroom who's familiar with the Lodge Freeway is thinking, wait, the entrance ramp is about 1 car wide. And as you're coming down it at merging speeds and a drunken idiot's coming the other direction at more than merging speeds, there's no place to go. There is a brick wall on one side or a cement wall on one side and a guardrail on the other side, and there's not room for 2 cars. Where can you go? And I remember the attorney for the drunk driver arguing and saying, Your Honor, but if they had simply stopped, hit their brakes and stopped, and my guy hit them, they might not have died. Therefore, the fact that they were, traveling at any rate of speed is their fault. And the sad part is I remember the judge very well. I can still remember the judge's name. He's retired now. He was a decent judge, but he's one of these judges who didn't like to disappoint people. And so he actually said, I'll take it under advisement, issue a written ruling. So I never found out what happened there. And I was always hoping I'd find out because I'm hoping the judge did a written ruling where he said, you lose. It's a stupid argument. Okay? Your drunk driver is going the wrong direction up an entrance ramp. You can't blame that on anyone but him, okay? But I don't know that happened. So again, crazy arguments get made all the time. And this National Law Review article points out, occasionally the courts get it completely right. Now, the fact they took it up on appeal just shows that somebody doesn't want to admit they've lost. But again, the Court of Appeals also affirmed this as well. So in case you're curious, for the 3 attorneys in my audience, 1070 Park Avenue Corp. versus Fireman's Fund Insurance Co. 2nd Circuit, July 2nd, 2019. You can look that up and read the opinion if you want to. But again, it was a summary opinion, very short opinion. But again, a rolling trash can or a dumpster or a trash receptacle is not a vehicle, no matter how badly you want it to be. And again, thank you, Josh. Questions or comments, put them below. Let's talk to you later. Bye-bye.